If you got married under statutory law and your husband dies, who how will the property be shared if there are no children, in that marriage? Now, if there are no children at all in that marriage, the wife, first of all, is going to be entitled to all the personal, belongings of the man, clothes, cars, all those things. Then, if there are leftovers, the law is going to consider the surviving parents of the man. So, but if there are children involved, the person the court consider is just the wife and the children. The legal wife is entitled to 1/3 of the entire property of the man, and his children are entitled to 2/3 of the entire property of the man, and it shall be shared equally among all his children, both those that were, giving birth outside the marriage, those that were giving birth during the marriage. All of them will share, the property 2/3. So the only time we can start talking about siblings, where siblings will partake in the sharing of the property, is if the man dies and he has maybe a wife. There are no children. There's no surviving parents. That is only when the law begins to consider the siblings. But as long as the man has a wife and the children, property is just going to be between the wife and the children. If the man has no children, but his parents are still alive. Now, that by the time you approach the probate registry, these things will be shared according to the law. Did you gain value from the video? Share with me at the comment section. I'd like to hear from you. Don't forget to give me a follow, like this video so you keep getting more legal tips like this. Thank you.